I'm happy that patent office is almost on an annual basis holding qualifying examinations for registration as patent agents. This is a very nice development. And one of the stock questions that are asked in the patent agent training examination is the foreign filing requirement. This is a very strange provision in the Indian Patent Act, and this provision will apply only to those people who are residents in India. In the case of natural person, we can find out and decide where is he domiciled. If he is domiciled in India, if he is a natural person, he should file the first application in India. If he does not want to file a first application in India and still want to file patent applications abroad, he should apply for this foreign patent filing permission. Alternatively, he can wait. He can file an Indian patent application, wait for 6 weeks, and if in the 6 weeks the office of the controller does not issue a secrecy direction, he can start filing foreign patent applications in respect of the same invention. Technically speaking, if one does not apply for a foreign patent filing permission, and when his first application for that invention is not made in India, then the application is deemed to have been abandoned and it deserves revocation under Section 24, and it can also be made a punishable offence under Section 115 of the Indian Patent Act. Okay, this is an irony. I think that why we have this provision? Okay, this question we need to ask. Now, the answer to the question why we have this Section 39 and 40 requirement is that if an invention has a bearing on the defense of India or it relates to the use of atomic energy, the government does not want these type of inventions to be published and be carried out the territories of India. So this is again a very debatable proposition, both in matters relating to defense and atomic energy. There is a lot of foreign companies seeking to invest in India, and many of them may also establish in India an R&D facility. And okay, let me not go into side stories. The main story is, under Indian law, if you are an Indian resident and come up with an invention, before you must apply in foreign countries, you must apply in India and wait for 6 weeks. And if the patent office does not issue a secrecy direction, you are free to apply for patents around the world. The other alternative is you don't want an Indian patent because you know that under Section 3, there are a lot of inventions which have been declared to be not patentable. For example, a prescription patent. Namely, old drug is used for the first time for treating an previously unknown disease with minor modifications, additions, and etc. etc. Okay, prescription patent. Mere new use of a known substance. This is not patentable in India. But these prescription patents are allowable in jurisdictions like United States, Israel. So you know that you are not going to have a patent for it in India, and there is no point in filing a patent application in India knowing fully well it is not going to be allowed. So as an inventor, you can take a decision. You will not apply for an Indian patent and yet like to take your chances in countries where they have a more patentee friendly patent systems. Okay, this is section 39 for you. Very recently, Madras High Court, in the case between Self Dot Technologies Limited versus Controller of Patent, had an opportunity to consider this issue, whether the requirement of a foreign patent filing permission is mandatory. If it is not complied with, will the patent office be justified in treating the patent application as abandoned? Okay. Now, in this case, the applicant filed for an application in India first, and a corresponding foreign patent for the same invention was applied in United States under the PCT route. Both in India as well as in United States, the first application for patent was granted. Now, during the subsistence of the main patent application, it was pointed out to the applicant or the patentee that there has been a new development in respect of the patented invention, and for them to protect that new development, they should apply for a continuation in part application, what is otherwise referred to as patent of addition in India. So the first application was filed. First application, you describe it as the main application, was filed in India as well as in United States after the mandatory waiting period, and both matured into a patent. During the lifespan of the main patent, the patentee realized that he has got an improvement which should be more appropriately protected by a patent of addition under section 54 and 55 of the Indian Patent Act. So therefore, the application he chose to make it in United States, not in India. And a corresponding application was also made before the Indian Patent Office. And the Indian Patent Office had pointed out, look here, you have not complied with the foreign filing requirement. You ought to have applied for a patent in India first. Alternatively, you ought to have at least applied for a foreign patent filing permission before seeking a patent of addition in the Indian Patent Office, and therefore treated the patent application for the patent of addition as abandoned. As against this order, the applicant patentee, the Self-Dot Technologies, filed an appeal before the Madras High Court. It is an appealable order. Okay. An order treating the application as being abandoned. Okay, fine. That's fine. The Madras High Court, in my opinion, had arrived at the correct decision. In fact, this judgment makes our patent system even more patent friendly. I mean, I am in full agreement with the judgment because I have always held an opinion. This Section 39 Patent Act is some weird provision in Indian patent law. Not many countries have this provision. The United States of America has it. China probably has it. Countries like Japan, South Korea, who are big filers for global patents, do not have this requirement. The simple reason is, hey, look here, if somebody thinks that they don't want a patent in South Korea or Japan and still feel that they will qualify for patent protection anywhere in the world, why prevent them from applying for it and getting it actually? That probably is the reason. Now, India, we have it because, in my opinion, the United States has similar provision. Even in United States, as well as in India, this foreign filing requirement does not apply to those patents which are filed abroad first, okay? Many countries do not have this requirement that foreign patent filing. Now, why do we have this provision? This is a question. After all, every legislation has a reason, and the learned judge of the Madras High Court considers that also in detail. Look here, you have something called Section 35 of the Patents Act. Under Section 35 of the Patent Act, if the application, patent specification, discloses an invention which would have a bearing on the defense of India, or if it is an invention relating to atomic energy, government doesn't want this information to go out of the country. So what they will do is, under Section 35, they will issue what is known as a secrecy direction. If the secrecy direction is given within about 6 weeks of the filing of the application, then this patent specification will not be published. If it is not published, you cannot request for examination. If it is not examined, it will not mature into a patent. So if it doesn't mature into a patent, you don't get a legal monopoly. So the secrecy direction could in effect result in denial of the patent itself. Okay. Now, this is a very interesting provision. Section 35 says that, we shouldn't apply for a patent outside the country without first applying for it in India. And under Section 35, if a secrecy direction is issued, it will not proceed for publication or even examination. So here in this case, there was a first application. That main application matured into a patent. That was admittedly not subject matter of a secrecy direction. So when there is going to be an application for patent of addition, in effect, there has been a compliance in spirit of Section 39 and 35. It's not going to relate to atomic energy. So, the learned judge of the Madras High Court, very rightly in my opinion, had concluded that this requirement is more procedural in nature. This should not deny the patentee a right to patent if the essential requirements for granting of the patent is complied with. The essential requirement for granting of the patent is novelty, utility, non-obviousness or inventive step, and statutory subject matter. So all the 4 essential requirements are complied with, then an applicant should normally be entitled for a patent. Over and above that, you have this procedural requirement under Section 39 that says, if you are an Indian resident, this is very important. It is domicile based, not nationality based. If you are a person resident in India, this is a good lecture. This is the terminology used in this section. You should first apply for an Indian patent. If not, you should obtain foreign patent filing permission. Apparently, this was not complied with. The learned judge remands the matter back to the controller and says, look here, there has been substantial compliance. Okay, number 1, he has met with the requirement of novelty, utility, non-obviousness and statutory subject matter. The main patent application had been made to the Indian Patent Office and no secrecy directions have been issued. So if there is going to be a patent of addition in respect of the main patent, quite naturally you can expect that the secrecy direction requirements will not be attracted. So therefore, the judge says, look, yeah, this is more procedural. Don't deny an applicant a patent merely because he has not complied with the procedural requirement. Consider this application afresh. And if there is a violation, impose on him terms and, reverse your order and send back the matter. I mean, I like this judgment. It lays down the right law. But the fact is, Section 39 requirement doesn't make sense in an economy like India. There are about 300,000 innovations are followed up by patent applications every year. In India, not even 60,000 are filed. In this 60,000 patent application, not even 25,000 applications are filed by Indian residents. Of late, more and more Indian residents and Indian companies are trying to take advantage of the international patent system. It's good and it's a nice development. And the judgment, in my opinion, it hasn't expressly said so. That is, under the traditional law, there is a doctrine called factum valid. Factum valid means what should have been done. If not done, what should have been done as per law? If not done in the same way as stipulated by law, can still be valid if what was not done relate to what is known as a formal validity. There are two types of formalities. First formalities are essential requirement. The second formality is formal requirement. Okay. So long as the essential requirements are complied with, even if the formal requirements are not fully complied with, the non-compliance of the formal requirements need not be fatal for acquiring a statutory right. The statutory right to patent should be available for any person who fulfills the requirement of novelty, utility, non-obviousness and statutory subject matter. These four are essential requirements and the applicant has complied with that. What the applicant here has not complied with is Section 39, foreign filing permission. First applying for it in India, waiting for 6 months, alternatively apply for permission. This, the learned judge considers it as a formal requirement. Non-compliance of a formal requirement is condonable, and he has directed the controller to reconsider the matter, and this is a nice development. I would say that we don't need this provision for India. This is an unnecessary bottleneck and it's subject to Indian applicants unreasonable fetters actually. Okay. So therefore, this is an area I think you should focus on and you are likely to get a question on this topic during the forthcoming examination. By the way, ladies and gentlemen, for those preparing for the examination, I have put up courses on Udemy. I have something like 20 hours of video spread over about 4 courses covering different aspects of industrial property rights, and it will be a good thing. Just look at the links below, and if you find the course that meets your requirement, please do enroll. Thank you.